ઓકે, કેટલો સમય લેશો? કેટલો સમય જોઈએ? હાઉ મચ ટાઈમ યુ રિક્વાયર? ઓકે, નેક્સ્ટ. Mr. VM Lacha. Yes. Proceed.
આખી ફરિયાદની અંદર જે ફરિયાદી જે છે બિંદીબેન જયેશભાઈ પંડ્યા, જે સાહેબ ટ્રાન્ઝેક્શન, લોભ, લાગણી, જે કાંઈ વ્યવહાર કહેવાતો વ્યવહાર જે કંપની સાથે કરેલો છે એ યતીન દેસાઈ, લતાબેન અને સાહેબ સ્મિત મુકેશભાઈ એમની સાથે. હવે સાહેબ અમે પ્રોડક્ટ મેનેજર, હવે ઓફિસની અંદર આવે સ્વાભાવિક રીતે, ઓફિસની અંદર આવતા હોય એટલે ઓળખતા હોય, હું માની લઈ. હવે કહેવાતા વ્યવહારની અંદર સાહેબ અમે કોઈ આવી રકમ અમારા ખાતામાં એકી સાથે આવી હોય એવું ક્યાંય પોલીસ તપાસની અંદર નીકળી આવ્યું નથી. જ્યારે પોલીસના સોગંદનામાની અંદર અત્યારે આવે સાહેબ, એમના કયા મુજબ મનીષાબેન રાજેશભાઈ પાનસુરિયાના સ્ટેટ બેંક ઓફ ઇન્ડિયાનું એકાઉન્ટ 100 નંબરથી યતીન દેસાઈ માલિકીની કંપની વાયુ નેચર કંપનીના ખાતા નંબરની અંદર 2,12,744 આવી રકમ આવેલી છે. સાહેબ મારું સ્ટેટમેન્ટ હું રજૂ કરું છું, 2000 છેલ્લા 3 વર્ષના હું રજૂ કરું છું સાહેબ. એની અંદર મારે આવી કોઈ રકમ આવી હોય એવું સાહેબ રેકર્ડ ઉપર ક્યાંય આ બેંક સ્ટેટમેન્ટ ઉપરથી નીકળી આવતું નથી સાહેબ. 2002 થી 20, 21 થી 23 સુધીના સાહેબ હું સ્ટેટમેન્ટ રજૂ કરું છું. હવે સાહેબ માત્ર હું કંપનીના મુખ્ય માલિકો સાથે જાતો આવતો અને સાહેબ આ પ્રાઇમા ફેસિક મારું ઇન્વોલ્વમેન્ટ નીકળી ઈરાદાપૂર્વક આ ફરિયાદી દ્વારા દેવામાં આવ્યું છે. બીજું સાહેબ કે અમે હાલના ફરિયાદીને ઓળખતા નથી, એ કંપનીમાં આવતા હતા, એ ડિરેક્ટરો માલિકો સાથે ડિસ્કશન કરીને જતા હતા, એ સાહેબ રેકર્ડ ઉપર છે. અને ફરિયાદીની ફરિયાદમાં આવે છે કે એની યારે કોઈ ટ્રાન્ઝેક્શન થયું હોય એવું સાહેબ ફરિયાદી પણ નથી કહેતા કે આમની યારે કોઈ ડીલ થયો, વાત થઈ હોય, એને લાલચ આપી હોય પ્રોડક્ટ. અમે ફક્ત અમારા કામમાં પ્રોડક્ટ મેનેજર તરીકેની ફરજ બજાવી, બીજા કોઈ સ્ટેટમેન્ટમાં સાહેબ મેં કે આવી રીતનો ભાગ ભજવો હોય એવું સાહેબ રેકર્ડ ઉપર નથી આવતું. અને જે ફરિયાદી જે આખી સ્ટોરી લઈને આવ્યા છે એ આખી સ્ટોરી જોઈએ તો માત્ર એક જ વસ્તુ આવે કે આ પ્રોડક્ટ મેનેજર હતા. એ તો હું છું જ, કારણ કે મારો ધંધો હતો, નોકરી. અને આ માની લઈએ કે આ અધિકારી આ કહે છે કે આ રકમ આવી, પછી એના કયા મુજબ એની કે સ્ટેટસ તો અમારો પગાર કંપની અમને ન આપતી હોય, અમે હું એમને કામ કરતા હોય. અને આ રકમનો ટોટલ એ બતાવે છે અધિકારી, એવો ટોટલ ક્યાંય મારા એકાઉન્ટમાં નીકળી આવતો નથી. અને અમે પોલીસ સાથે અમે નતા ભાગ્યા, અમે સામે ચાલીને હાજર થવા ગયા, ફરારે નહોતા. અને ઘરની તમામ જવાબદારીઓ અમારી ઉપર છે. નાના નાના છોકરાઓ છે, વૃદ્ધ ઉંમરના પિતા છે સાહેબ. આવા સંજોગોની અંદર ગંભીર ગુનામાં અમને સંડોવાયેલો હોય એ તમામ સંજોગો ધ્યાને રાખી સાહેબ અમને એવી શરતોને આધીન મુક્ત કરવા વિનંતી છે સાહેબ. આપણા સહકૌમાનદારને આપ સાહેબે જોયા સ્મિત મુકેશભાઈ એનું કોપી પણ રજૂ કર્યું છે.
યસ રાજેશ.
હાજી, હાલના અરજદાર આ કંપનીમાં પ્રોડક્ટ મેનેજર અને માર્કેટિંગનું કામ સંભાળતા હતા. તેમજ અલગ અલગ જિલ્લાઓમાં અને રાજ્યોમાં સેમિનાર યોજાય ત્યારે એ સેમિનારમાં પણ આ રાજેશ લાલજીભાઈ પાનસુરિયા હાજરી આપતા હોય અને તપાસ દરમિયાન આ એમના પત્ની મનીષાબેનના ખાતામાં નાણાં જમા થયેલા છે યતીન દેસાઈ ના કોર્પોરેશન બેંક ખાતામાંથી અલગ અલગ તારીખે 5,83,216 જમા થયા છે. બે આંકડા બતાવેલા. 2,12,744 જમા થયાનો અલગ અલગ તારીખે. એટલે એ રીતનો એમનો કંપનીમાં પણ માર્કેટિંગની ભૂમિકા છે. એટલે માત્ર મેનેજર નહીં પણ સહ આરોપીઓને જે કાર્યવાહી છે તેની મદદ માટે પણ અરજદારની ભૂમિકા હોય તે ધ્યાને લઈ અરજી રદ કરવા રજૂઆત છે.
You are denying the fact that the amount is deposited in the account of your wife.
વાઇફના એકાઉન્ટ મારી નામનું હતું.
તમારું એકાઉન્ટ નું કોઈ કામ નથી. એમનું કહેવું એવું છે કે તમારા વાઇફ મનીષાબેનના ખાતામાં જમા થયા. એનો તમે ઇનકાર કરો છો?
ના સાહેબ નથી.
તેને એક્સપ્લેન કેવી રીતે જમા થયા, શેના જમા થયા?
અમારો પગાર જમા થયો છે ઈચ્છે છે.
કોઈ એપોઇન્ટમેન્ટ ઓર્ડર આપની પાસે કે તમે પગારદાર એમ્પ્લોયી હતા?
ના સાહેબ એ પગાર અમને એમનો જ ચૂકવણું કરતા.
કારણ કે આપ એવું કહો છો કે પગાર હતો એટલે કઈ એવું તો નક્કી થયું છે ને તમને નિમણૂક આપી હોય આટલા રૂપિયા પગારથી કેવું કઈ?
ઈ જે એમનો કેસ ને મારા અધિકારી સાહેબ ઈ કોઈ એવી રકમ એકી સાથે નથી કહેતા. કટકે કટકે જે માનો કે
હું પૂછું એનો જવાબ દો ને વકીલ સાહેબ. આપનું શરૂઆતથી એવું કેવું છે કે હું પ્રોડક્ટ મેનેજર છું.
હા.
આપને કોઈ એપોઇન્ટમેન્ટ આપી હોય, કોઈ પગાર નક્કી થયો હોય, કટકે કટકે પગાર જમા થયો હોય,
પગાર
એવું કઈ બતાવી શકો છો? કેટલો પગાર હતો આપનો?
20,000 રૂપિયા પગાર.
એ પણ આપણને ફાઇનલ ખબર નથી.
હા તો એ બેંકમાંથી જે અમુક બેંકમાં આપે ત્યારે રોકડા આપે અને જે ફંક્શન નું જે
કંઈક તો હોય ને રેકોર્ડ.
હાજી
પગાર આપતા હોય તો બેંકમાં જમા થયા હોય તો તમારા ખાતામાં જમા થાય. તમારા વાઇફના ખાતામાં શા માટે જમા થાય? જો તમારા કહેવા મુજબ પગારની રકમ છે, પગાર એમ્પ્લોયના ખાતામાં જમા થાય, એની વાઇફના ખાતામાં ન થાય.
વાઇફના ખાતા હું અમે પોતે જ મારા વાઇફનું ખાતું અમે પોતે જ ઓપરેટ કરતા.
તમને ગળે ઉતરે છે તમારી આ દલીલ? મને નથી ઉતરતી.
ના સાહેબ વાત સાચી છે, આપની વાત સાચી છે.
તમને તમારી આ દલીલ ગળે ઉતરે? ઇઝ ઇટ પેલેટેબલ?
યસ સાહેબ.
પેલેટેબલ?
નહીં સાહેબ. એમાં જેમ મારા મિત્ર જે આપ કહો છો કે હું બતાવી શકું પણ અત્યારે મારી આગળ બતાવવા માટે આપની પાસે મારી પાસે નથી આધાર.
શેના આધારે આપ કહો છો કે તમે આમાં ઇન્વોલ્વમેન્ટ જ નથી?
મિસિસના એકાઉન્ટમાં અધિકારી કે છે
તમે એમ્પ્લોય છે એવું બતાવવા માટે પણ તમારી પાસે કાંઈ નથી.
એમ્પ્લોય
આ રકમ તમારા ખાતામાં શેની આવી એનો ખુલાસો તમારે જ કરવો પડે.
હા સાહેબ એમ્પ્લોય છું, હું નોકરી કરું છું તો હું પોતે એક્સેપ્ટ કરું છું ને. અને ઓર્ડર અમને આપેલો નથી સાહેબ. ઓર્ડર અમને નથી આપ્યો લેખિત. એ હું આપને થોડું કહું.
ઇઝ હી પ્રોપરાઇટર?
ના, પ્રોપરાઇટર નથી, મેનેજર,
પ્રોડક્ટ મેનેજર ખાલી.
હું એમને પૂછું.
સોરી સાહેબ.
હેવ સમ પેશન્સ.
જી સાહેબ.
પ્રોડક્ટ મેનેજર.
ઓલરાઈટ. ચાર્જશીટ થઈ ગયું છે રાજેશ?
બાકી છે.
તમે કોપી રજૂ કરી છે બીજા આરોપીને જામીન પર છોડ્યા છે એની?
હા સાહેબ.
ક્યાં છે? કોઈ ક્રિમિનલ એન્ટિસિડન્ટ્સ રાજેશભાઈ? બીજા કોઈ ગુનાઓ? મંજૂર કરવામાં આવે છે. નેક્સ્ટ. 10 દિવસ પછી તમને સાંભળીશું. એક એજન્ટ કરો. 19 તારીખે સુનાવણી થશે તમારા કેસની. 19 તારીખે સુનાવણી થશે. યસ. નેક્સ્ટ. કેમ?
ટ્રાન્સફર પિટિશન.
કઈ હિયરિંગ થયું છે?
Yes, last time, sir, argument for the applicants were concluded, then the matter is called for the calling the recurring proceeding from the trial court.
રેકોર્ડ આવ્યો નથી. એજન્ટ કરીએ છીએ. યાદી કરીને ફરીથી મંગાવી. નેક્સ્ટ. જામીન અરજી છે. સાત દિવસ પછી. 7 દિવસ પછી. નેક્સ્ટ. કોઈ હાજર નથી, કોઈ રિપોર્ટ નથી, એવું નોંધ કરજો. યસ, કોઈ અભિપ્રાય આવ્યો નથી એમાં રોહનભાઈ?
પાસપોર્ટ અત્યારે આપ્યો હતો પણ 3 તારીખ છેલ્લી મુદત હતી, પણ પાસપોર્ટ હજુ પાસપોર્ટ ઓફિસમાંથી આજ પરત નહોતો આવ્યો, એટલે છે એક દિવસ આગળ કરી રાખેલ છે, હજુ આવ્યો નથી, તો પછી હવે આવી ગયો છે,
રજૂ કરી દો છો.
એટલે હજુ આ વસ્તુ પર ઓર્ડર છે, એક દિવસ પેલો લેટ આવ્યો હતો.
તમે એક્સટેન્શન માંગો છો?
સર જ્યારે અરજી દાખલ કરી હતી ને 3 તારીખે, એટલે જે દિવસે મુદત પતવાની હતી ને એના આગલા દિવસ સુધી અમારા હાથમાં
એક ફોર્મલ એપ્લિકેશન આપીને લખો ને કે આ એક દિવસ મોડું થયું છે. કેટલા દિવસ પૂરતો આપ્યો તો તમે?
2 મહિના.
ક્યારે ડેડલાઇન ક્યારે પૂરી થાય છે? ક્યારે પૂરી થઈ?
2/5 2 કે 3 2/5 3 તારીખે, એટલે એક દિવસ, હા 2 તારીખે પૂરી થઈ.
2/5.
2/5
હમ.
પણ સર આમાં કેવું છે, એક દિવસ પહેલા, એટલે મેં મારું બોનાફાઇડ બતાવવા માટે કે એક દિવસ પહેલા સુધી મેં વેઇટ કર્યું, પણ આ શોન મેં બોનાફાઇડ કે હજુ મારા હાથમાં જ નથી આવ્યો, એટલે અરજી કરી રાખેલી, પણ આ અરજી બોર્ડ પર આવી ને ત્યાં સુધીમાં સર મારા હાથમાં આવી ગયો.
તમે રિન્યુ કરવા માટે પાસપોર્ટ લીધેલો?
હા.
કઈ વિદેશ જવાનું નહીં હતું?
પાસપોર્ટમાંથી મારી પાસે.
રિન્યુ થયેલો પાસપોર્ટ રજૂ કરવા પરવાનગી આપીએ છીએ. નેક્સ્ટ. યસ મિસ્ટર આહિર. Are you Mr. Ahire? Are you Mr. A.D. Ahire? What is your initial? Your sign is there in the Wakalat memo?
No, my lords.
Then how can you argue?
I'm appearing on his instructions. Along with him, I'm appearing. If my lords wants, I can immediately sign on the.
Any proxy letter or where is the proxy letter?
Giving the
It is not the system here that anyone can address this court on behalf of anybody unless the authority letter is produced.
I'm sorry, my lords. I was.
Yes,
Yes.
yes.
Yes, my lords. But so this is a second anticipatory bail application. And there is a little bit of history which I must first appraise my lords about what has happened in this matter. May I invite my lords' attention to the document produced at serial number 10 of my compilation, which is the judgment of the Honorable Supreme Court.
Page number, annexure, annexure.
Annexure K, my lords. Annexure J, my lords.
Order of
Honorable Supreme Court, my lords.
in SLP 32555.
Yes, three two
Yes.
double five. Lordship, on the second page, on the bottom of the first page, delay in refiling is condoned after hearing the learned counsel for the petitioner and the learned counsel appearing on caveat. We do not think that the petitioner has made out a case for interference. Now, this is under the Article 136. The special leave petition is dismissed pending application stands disposed of. However, we make it clear that the dismissal of the special leave petition does not mean that this necessarily should lead to the arrest of the petitioner. It is for the authorities to decide as to whether an arrest is required for whether the provisions available in law by which the petitioner can be interrogated without arrest suffices. Needless to say, any observation made in the impugned order is made only for the purpose of passing the order, and it shall not trammel the court in any proceeding against the petitioner. So, Lordship, what had happened?
Wait.
Yes.
Are you in hurry?
No, not at all. I'm in my Lord's hands.
I have not speed of stenographer. Yes,
I'll
proceed.
be slow.
Yes.
Sorry. So what had happened, my lords? I had prepared an anticipatory bail application before this honorable court, which came to be rejected on merits. I prefer anticipatory bail application before the Honorable Gujarat High Court. Gujarat High Court, first the rule is issued. Subsequently, I was granted interim protection. After interim protection was granted to me, I attend the police station, I submit whatever documents they require. They ask me to submit my SIM card. That SIM card is submitted. And I'll explain the relevance of why SIM card was submitted and why SIM card was demanded after a while. But first, let me make my lords run through the procedures that were followed prior to coming here. After I was
So according to you, you have cooperated with the investigation.
I have cooperated with the investigation. Subsequently, the advocate for the complainant, the intervener before the Honorable Gujarat High Court, he files a compilation of the documents, and then an allegation is made that certain facts I have not disclosed. Accordingly, my interim was cancelled and my anticipatory bail was
Have
rejected.
you produced the order of that, the anticipatory bail application filed before Honorable the High Court?
A copy of the anticipatory bail application.
Yes, the order of the Honorable High Court.
Honorable High Court order I have not produced. I'll produce that, my lord requires. Because subsequently, Lordship, then that order is as such, then the scope of the order was limited by this order of the Honorable Supreme Court, wherein subsequently the paragraph which I will read for my lords. The last paragraph of the SL order passed by the Honorable Supreme Court.
So that
The order, and it shall not trammel the court in any proceeding against the petitioner. That is the reason I thought that I may not burden my Lord's court with that.
So
order.
Honorable the Apex Court has thought it fit to not to interfere with the
Yes.
order of the Honorable High Court.
Yes. But that order is then limited. The observations in the order are limited only for the purpose of the anticipatory bail that was argued before.
And simple observation is there that it is for the IO to decide.
Yes, it is for the IO to decide. That observation is there. And however, the Honorable Supreme Court subsequent also records that dismissal of SLP should not necessarily mean that it should lead to the arrest of the petitioner. Let the authorities decide if the investigation can be completed without my custodial interrogation. So essentially, it is falling from the Honorable Supreme Court, the apex court of our land, that though we are dismissing the SLP, we do appreciate that ultimately the underlying transactions are commercial in nature. All entities involved are businessmen from across different parts of the country. And
Why you have not produced the order of the High Court?
that's
As
why-
Honorable Supreme Court has observed that they are not going to interfere with the
Yes.
order.
yes,
What
produce-
was observed in the by the High Court while
I-
rejecting your
which I'm pointing out, my lords, that what was the
why it is suppressed?
no, not suppression. In fact, I'm orally making a statement. It's not suppression. I mean, that's not the intent. Only thought instead
When
of
you are drawing the attention of this court on a chronology,
yes,
why that order is not produced?
my lords will keep back. I'll produce the order right away. My lords will bear with me for 10 minutes if my lord. I mean, if I wanted to suppress it, I would not have pointed it out on my own accord. The only reason I have not produced that order is because the SLP order says that the observations there should be limited to that court and no other court should then as such be trammeled or influenced by the observations in that order. That's the only reason I have not produced.
Yes.
Because then as such, then it loses relevance so far as my fresh application is concerned.
Yes.
Now, my lords will appreciate this is an order passed in December 2022.
Which order? Apex Court.
SLP. Yeah. Apex.
December.
Yes.
December
December 13, my lords.
22.
22. Yes.
Yes.
Thereafter, my lords, I have produced 3 letters, which I have returned to the learned investigating officer. One is dated 20th March 2023. Second is 11th of April 2023.
Explore.
Yeah.
First one was of
20th March 2023.
yes.
11th April 2023.
Yes.
And 20th May 2023. Thereby requesting the learned investigating officer that I am available on so and so address. If you want me to attend the police station, kindly give me a 5-7 days advance notice. And there is one additional letter which I am submitting across, and I'm making this statement on instructions. There is a letter prior to March, towards the end of Jan or first week of Feb, which was sent to the IO, but I do not have the acknowledgement of that right now. I might have misplaced it. But because the letter I had sent, so I can vouch for it that I'm making a true and correct statement as an officer of this court. So December, the order is passed. Towards Jan end or Feb first week, I make the first letter, which is not there with me. Then in March, again I send letter. Again I send letter in April. Again I send letter in May. Around 12th of May, the investigating office, the team of the investigating officer had visited my residence. At that time, I was in Saudi Arabia for my Hajj program, for my Hajj visitation. The learned investigating officer had also contacted me personally and met me. And I had informed him that he's traveling.
How he contacted you?
He took the number from the mother of the...
So on a mobile phone.
On mobile phone.
On
he
phone
met,
call.
yes, phone call, and I have met him and I have told him that he's not there. And I told him that, we have written letters. You tell us whenever to come.
Had you informed the IO that you are going to perform the Hajj for so and so period?
No.
On which period you went for the Hajj?
Around 23rd or 24th of April, and I came back around 10th or 12th of May. And 2-3 days prior to that, the team of the investigating officer had visited.
So thereafter, you have written the letter of 20th May.
Again, 20th May, again, I wrote the letter. Please let me know whenever you want us to come. And every time I have communicated the order of the Honorable Supreme Court also, and I have also, in one of the letters, I have also, as a matter of abundant precaution, I have also communicated all the ledger statement. Now what happens, my lords? Why my SLP came to be rejected is because one of the co-accused had also filed a caveat before the Honorable Supreme Court, and he made a statement before the Honorable Supreme Court that I am also not making payment to him.
Who was that?
One Mr. Sanjay Shesh.
Sanjay.
Shesh.
He is co-accused.
He is co-accused. So he makes a statement before the Honorable Supreme Court that whatever goods I have purchased from him, I have not made payments. Substantial amounts of payments are not made to them.
Yes.
And now there is a dispute. And basically he wanted to prejudice my case, and I lost it there. Because ultimately the Supreme Court thought it fit that maybe we should not interfere at this stage. Subsequently, on January 25, 2023, he files a complaint before Bhaikala Police Station, Mumbai.
Oh, this is
Sanjay Shesh.
yes.
And he makes a statement there that I have to pay him 10 crore rupees. Now, Bhaikala Police then issues a notice to me. I have got a separate compilation wherein that notice is also produced. And now every day, a new torture as such starts, wherein I am now being forced to, or where now I am being called upon to make payments to him. Now, the only difficulty I am facing, my lords, is that I had stopped the payments to co-accused Sanjay Shesh on account of this FIR. Now he goes and registers another false complaint before Bhaikala Police Station. The FIR is not registered there, only its complaint, and I was issued a notice. Subsequently, I realized that let me make all my payments, let me clean my books, and then deal with the issue. But then I am advised by my counsels that there is one standing FIR wherein I have congratulated myself 50% in view of the Supreme Court order, because though SLP is dismissed, the Supreme Court at least grants me some comfort while recording that it should not necessarily lead to arrest. Then I make an offer of whatever the outstanding dues are there. I make an offer to the original complainant in this matter. That letter, my lord, is produced at Annexure L. So first I send him by post letters. First I send him by hand letter. They refuse to accept it on the ground that we are not supposed to accept advocates' letters. Then I send him by post. The post is returned, and then I send him an email. That email along with the letter is there on 1st of June 2023. Sorry, 31st of May 2023. Lordship will find that at Annexure L.
Yes.
Yes. So this email is addressed by me. Dear sir, madam, we are concerned for our client, Mr. So-and-so. Please find attached settlement letter on behalf of our client, Sri Mudassir Ansari, the contents of which are self-explanatory. You are requested to kindly take the same on record and communicate your response on the same. In the event you require any clarification or wish to check the ledger and books of accounts, please feel free to communicate the same to the undersigned. Kindly take the same on record and acknowledge the receipt. Now, what do I write in this letter? The next page. The letter is dated 31st May.
Yes.
I have stated that there is an FIR. I have stated that whatever has precipitated, and I have then stated that as per my books, around 3 crore 33 lakh rupees are due and payable to Yogiraj Metro and Phoenix Infra, which are the firms of Sanjay Shesh, co-accused. Sanjay Shesh is the same co-accused who had registered a complaint against me in January 25.
Yes.
And then I make a request that if you accept this, I have only two requests to make to you. One is that we will essentially have to make the journal entries, because if I'm making you direct payment, tomorrow it should not happen then that the same money is then claimed by Sanjay Shesh also from me. So I make him that request that we'll have to work out something on those lines, and then you'll cooperate with us for caution by consent. Now there is no reply to this. And side by side, Bhaikala police station is again pressurizing me that either you make the payment or we'll register your FIR and we'll arrest you. Now I am juxtaposed and I am cornered from all directions. Then what I do, my lords? May I tender? This is the additional documents which I could not produce at the time of filing of the anticipated. So, then I execute a deed of settlement with him, because he originally registers a complaint demanding 10 crore rupees. Then both of us, we sit, we check the ledgers.
So I don't know actually at this juncture what is the fact of original complaint is.
Yes,
Because you are just drawing the attention of this court on the dispute between you and that's Mr. Shesh.
yes.
What was
May
the
I
original
now
dispute?
point
What
out,
was the
my
release?
lords,
I don't know.
Yes. Lordship, in this compilation only, I have
How it is connected with this
yes.
complaint.
May I, in this compilation only at page 148, I have produced the translated copy of the FIR, and I would beg my lords a little accommodation. My hands on Gujarati language is little weak.
No issue.
So
Language will
yeah.
not be a big issue.
Yes, so that's the reason I have produced the English translation. At what if I would run my lot through the English translation if it is
Which page? Page number?
148 months.
Yes.
Yes. So before making my lords run through the line by line statement of the original complaint, I'll explain the gist of the allegation in brief. There is one entity called as one Mr. Shailesh Kumar Agrawal, who is owner of a company called as Adarsh Coal Hub LLC.
He is a complainant.
He is the complainant. Adarsh Coal Hub has some pre-existing business with one entity called as Sunshine. Sunshine has a broker called as one Mr. Deepak Dholu. Adarsh Coal Hub had been selling coal through Mr. Deepak Dholu to the Sunshine company. And in view of this, they had a long-standing relationship with one Mr. Deepak Dholu. Deepak Dholu then proposes to Adarsh Coal Hub that he knows another party by the name of Yogiraj Metro OPC Private Limited. The owners of that firm are Sanjay Shesh of Yogiraj Metro, who is the co-accused.
Yes.
And they need a lot of coal. They have started some new steel plant.
Yes.
And hence, would you be interested? And he says, yes, I am interested. Then he supplies the coal through Deepak Dholu to Yogiraj Metro OPC Private. The allegations thereafter are that they start supplying the coal and a payment of around 2 crores is paid, coal of around 2 crores is supplied, and a payment of around 2 crores and some odd lakhs is made. Then more and more coal is demanded and more coal is supplied. While these transactions were being executed, Deepak Dholu then states to the complainant that, sir, why don't you transport your coal through one Mr. Asif Sheikh, who has some relationship with Sanjay Shesh, and he only does all his work of transport. So it will be convenient and logistically good for you. So the complainant says, okay, fine, I will make the transfers through, I will execute the transport through Asif Sheikh. And accordingly, coal worth another 8 crores was supplied to Yogiraj Metro OPC Private Limited. Then Deepak Dholu and Asif Sheikh says that Mr. Sanjay Shesh also owns another company. That company's name is Phoenix Infra. And that company's purchase manager is one Mr. Nandu Bhai urf Mudassir Ansari. So Sanjay Shesh owns two companies, Yogiraj Metro and Phoenix Infra. Deepak Dholu, after the coal is being supplied to Yogiraj Metro, while the coal was being supplied to Yogiraj Metro, somewhere in between, he states that Sanjay Shesh has another firm and Mudassir Ansari, Nandu Bhai of Mudassir Ansari is the purchase manager. He will supply,
He's a present applicant.
he is the present applicant. Now, according to the complaint, another coal worth 74 lakh rupees was supplied to Phoenix Infra. Allegedly, the purchase orders were placed by Mudassir Ansari.
Yes.
Subsequently, there is some dispute between Sanjay Shesh and the complainant, the first informant, and they send some debit notes to them. Thereafter, they file a complaint before Bhivandi police station in on the outskirts of Mumbai. There nothing happens. Then they go to Varacha police station in Surat, and a FIR came to be registered.
Yes.
And a FIR came to be registered, and hence the consequential applications.
Yes.
Yes. Now, my lords, when I was granted, now one more additional fact which I must first point out before I narrate my story of what happened after I was given interim bail. Now, Sanjay Shesh had purchased coal worth approximately 10 crore rupees, out of which 2.5 crore rupees are paid to them, and 8 crores and some odd lakhs is pending as per the complaint. I have purchased coal worth around 24 crore rupees from Sanjay Shesh. And the payment of around 22 crores is already made. As on date. So around 1.79 or 75 lakhs are 1.75 crores are pending.
You were a product manager.
I was
Purchase
not.
Purchase manager of this Sanjay Shesh.
No, I was not. That's the allegation. And that is where I'm drawing my lord's attention to.
Yes.
I was not.
You are
Because
denying that fact.
I'm denying that. I'm denying that. Because, and lordship will please appreciate how the prosecution story is botched up. The entire pillar of conspiracy and the entire matrix of commission of crime is based upon 4 pillars. One is that Deepak Dholu introduces me to Sanjay Shesh as some owner of the steel plant or some factory. Second pillar is entire transport is done by Asif Sheikh on the instructions of Deepak Dholu or on the request of Deepak Dholu.
Yes.
Third is I acted as a purchase manager. And fourth is no payments were made.
Yes.
Now, the first contention of the complainant is that the entire coal was transported through the company of Asif Sheikh. When Asif Sheikh approached this honorable court, he makes a categorical statement that I have not transported coal worth 8 or 10 crore rupees. I have transported coal worth some amount, maybe 10% of whatever is being claimed. A supplementary statement came to be recorded, wherein now the complainant says that yes, he is right. Coal was also transported by other 70-80% or some percentage. I mean, may not be exactly right about the percentage. X percentage of the coal was also transported by other transporters. Now, why the first false allegation was made when you yourself are aware that the entire coal was not transported to Asif Sheikh? It was only to show that, see, because transporter was also belonging to their gang, hence there was no way anybody could have pointed out to me that there is no factory. So now we boil down to the second allegation, that there was factory and that is why I gave the coal. Now lordships are aware that under the GST regime, if a coal is being supplied to end consumer, that is a factory. If any goods, any raw material is being supplied to an end consumer, that is the factory, then you have to submit Form 27C. If you are supplying to a trader, then you deduct 1% TCS. All that the complainant has to come forward and show is that whether he has submitted Form 27C or he has deducted 1% TCS. That will draw the demarcation about your knowledge, that whether you are supplying the coal to a trader or whether you are supplying coal to a factory. Because if you are supplying coal, because if it is in your knowledge that you are supplying coal to a trader, then this entire deception of creation of a factory or existence of a factory falls. For that, you have to produce Form 27C. But if you have deducted 1% TCS, that means you were aware that it has to be supplied, that you are supplying coal to a trader.
Yes.
Now, out of these 8 crore, 9 crore goods that were supplied to Sanjay Shesh, me in my partnership from Limra Fuel, my proprietorship from HN Trading. HN Trading is proprietorship of my mother, but I handle the business. My mother is a senior citizen. And third is SHN. SHN is where me and Asif Sheikh are the partners. Now, when I was granted interim, 3-4 basic questions were asked to me. One is, does this mobile number belong to you? From which the complainant is saying purchase orders were placed. I say yes. Investigation says, okay, fine, deposit your SIM card. I say, okay, fine, take it. They say, where you purchase manager? I say, no. They asked me a couple of other questions to which I answer. And it is my case that the investigation was always aware that I have purchased the coal from Yogi Raj, and which I have made categorical statements in my anticipatory bail applications even before the Honorable Gujarat High Court. But somehow I, as a counsel, failed to convince Gujarat High Court, Honorable High Court, that this fact was always known. But then subsequently the complainant comes forward and produces the GST ledger and says that, see, they have purchased so much of coal from these entities. And then somehow the court felt that we have suppressed this material information that we have purchased the coal. That is the reason my anticipatory was rejected.
Yes.
Now I ask, time and again we have been agitating that if I have acted as a purchase manager of Phoenix Infra, you should have at least one phone call, one message, one WhatsApp chat placing, because if a purchase order is being placed for 74 lakh rupees, you are essentially talking about that almost 21 truck purchase order was placed by me by acting as a purchase manager of Phoenix Infra. Then you should produce at least one chat, one message with me. But nothing of that sort is produced even till date. Essentially, I lost the battle of perception. Essentially, I lost the battle of perception, my lords.
Yes.
And when Honorable Supreme Court was almost inclined, because I was arguing before Honorable Supreme Court there, personally, I had the opportunity to appear there. Even at that stage, I mean, unfortunate on my part that the co-accused comes forward and then makes a statement that even my payments are pending, is not making a payment. And whatever the court felt in its infinite wisdom, my SLP was declined. But keeping in view that these are essentially transactions which are commercial in nature, the court subsequently records them. Now, my lords, I am making a specific request before this honorable that today investigation is pending from 2021. FIR is of 2021, my lords. November 2021.
Yes.
I am ready and willing to attend the police station. I am ready and willing to furnish all sureties. If the allegation on me is for 74 lakh rupees, lordship, I will deposit 74 lakh rupees tomorrow before this honorable court. Because I have purchased the coal, I have to make the payments. I have no dispute about it. Either I make payment to Sanjay Shesh, or I make payment to, or I deposit the money in this honorable court, or I make payments to the complainant. Only if I am making payment to the complainant of that 74 lakh rupees, I would only request that they may pass on appropriate journal entries so that the ledgers can be accordingly adjusted for all three entities. And today, lordship, ultimately Supreme Court says what? Supreme Court in its infinite wisdom has clearly indicated, and lordships, indication by a court is nothing less than an order. Supreme Court in its infinite wisdom had indicated that investigating authorities to decide whether under the provisions of law, investigation can be completed without custodial interrogation. I am writing letters after letters to you. If you issue me a notice parallel to the notice of a 41A, if you issue me a notice and call upon me to come forward and produce ABCD documents which you require, I would have gone ahead and produced it. And today also, while I'm standing before my lords, I have got all the ledgers duly audited, duly signed by all the parties, and also audited by my chartered accountant. Ultimately, it's a commercial dispute.
You sum up.
Sorry, my lords.
Sum up now your argument.
Yes, my
You have
lords.
taken much time.
So, I'm sorry, my lord, but I must thank my lords that my lords have heard me patiently. Lordship, may I quote some law on this, my lords? Or I'll just tender across the judgments. I'm sure my lords are any which is aware about. I was about
Which
to quote.
judgment you are relying? You are making the record bulky. It's a short question to be decided. You are making the record bulky.
Yes, I will not make it. I'll hold on
And
to my
on-
judgment. The law is very
On
clear.
which
Otherwise,
authority you are relying?
Lordship,
Which
Sushila
judgment?
Agrawal is there. Gurbakh Singh Sibia is there.
Okay.
Lordship, Sushila Agrawal is there. Gurbakh Singh Sibia. Then State of Uttar Pradesh versus Devman Upadhyay. The State of Uttar Pradesh versus Devman Upadhyay, I was only intending to point out because ultimately a person who offers himself to subject himself to the investigation, then it amounts to the court invented the concept of deemed custody under section 27 of the Evidence Act. So if I am consistently offering myself that if you want me for investigation, please give me a notice, I'll appear, at least give me 3, 4, 5 days, 7 days notice, I'll produce all the documents. So if I'm then technically, for all practical purposes, I have subjected myself to the custody. Lordship, only this judgment will. And last but not the least, Lordship, in the Indian Oil Corporation, Lordships are aware about this matter also. The ingredients of section 420, Lords, only because goods have traveled to me at the end and for which I have made lawful and genuine payments. And as per the story of the prosecution itself, that all the misrepresentations were made by Dolu. Alleged misrepresentations, in my personal knowledge, I do not think Mr. Dolu has made any misrepresentations. Complainant was aware all throughout that he is supplying coal to the traders. The complainant himself revises his statement, improvises his statement, and that act itself amounts to failure of his own charge of conspiracy. And what are what are those 4 golden questions that the investigation is going to ask me or interrogate with me from the in the custodial interrogation, which could not be otherwise answered? Today, my lords, I am being cornered from all 3 corners. I mean, I'm intending to subject myself to the investigation, but I do not know whether I'll be arrested or not. No notice is being sent to me. On the other side, Bhaikala police station is pressurizing me, for which then ultimately I make an offer to
Was
the
it
company.
directed by the High Court to
Sorry.
issue the notice?
Sorry, my
To,
lords.
is there any direction of Honorable the High Court? Prior
Supreme
to
Court,
making
no.
arrest, they have to send the notice.
No,
of
there is
the-
no direction. But ultimately, lordship, the direction by the Honorable Supreme Court is that investigating authorities to decide.
That is true.
But that decision has to be based upon a rational and reasoned opinion. And then it is my case that you have to make a parallel of section 41A,
Well,
record
it
your
is not
reasons.
directed to convey you their opinion.
They have not directed to. No. So, lordship, they are under no obligation to communicate their opinion. It is always their discretion. But I'm not on the point of their discretion alone. I'm saying that ultimately, in fact, lordship, now lordships are aware that under Sushila Agrawal, the earlier opinion that 438 does not flow from Article 21, that has now been revised. And in Sushila Agrawal, Honorable Supreme Court has stated that the original intent of the Gurbakh Singh Sibia was that ultimately the rights under 438 are part of Article 21. So ultimately, lordship, I am only here to make my agitation that I do not know whether I'll be arrested or I'll be taken in custody for 1 day or I'll be taken in custody for 15 days or for how long. All I need is a clarity, please. And I am a law-abiding citizen. I might have committed some mistake in terms of, okay, fine, I indulged into a trade with an entity who had subsequently some dispute and which led to a FIR. I will learn through my life experiences, but today I am ready and willing to subject myself to the investigation. Allow me to go and protect my liberty. And tomorrow again, if it is found that I am not cooperating, lordship may cancel my interim if my lords are inclined to grant me interim today. And if my lords are inclined to protect me today, then they always have an option.
Cancellation is a very.
In fact, I may point out, lordship, in the matter of Sudhir, I have got that judgment also, just to point out that cancellation is difficult. I understand it has to be under extraneous circumstances. But lordship, may I also point out a judgment against me as an officer of my Lord's Court that in Sudhir versus State of Maharashtra, which was subsequently affirmed by Honorable Supreme Court, wherein anticipatory bail was granted, second anticipatory bail was granted, which was because the applicant was then not cooperating with the investigation. Subsequently, the High Court cancelled it and Supreme Court affirmed the cancellation. So the weightage, my lords, is vis-a-vis whether is there anything for which my custody requires, vis-a-vis, lordship, my rights under Constitution of India. When I'm producing documents to show that I'm ready and willing to cooperate. With this, lords, I humbly beg before my lords that if my lords will be pleased to protect my life and liberty and grant me the benefit of 438 of the Criminal Procedure Code, I'll be obliged. I'm obliged.
Yes.
હાલના અરજદાર આરોપીનું નામ પ્રથમથી જ FIR માં છે આરોપી નંબર 5 તરીકે.
First, you inform the court that whether it is your opinion that you require the custodial interrogation for
હા સાહેબ, કસ્ટોડિયલ
any
ઇન્ફોર્મેશન
of the grounds. So without custodial interrogation, investigation can be going on. Supreme Court નો હુકમ એવું કહે છે કે તમારે એવો અભિપ્રાય, it is for the IO to decide કે ઇન્વેસ્ટિગેશન એરેસ્ટ કર્યા વગર થઈ શકે તેમ છે કે કેમ. સુપ્રીમ કોર્ટે ઇન્ટરફિરન્સ નથી કર્યું, પણ એમાં લખ્યું છે કે it does not mean કે arrest is necessary. એટલે સુપ્રીમ કોર્ટે it was left to the IO on the wisdom of the IO that whether arrest is required, whether custodial interrogation is necessary, you have to form the opinion.
આમાં સાહેબ
If your answer is yes,
હા એટલે
then you have to state the reasons.
એમને જરૂરી છે એમ.
તમે જરૂરી છે એવું માનો તો તમારે એના કારણો મને આપવા પડશે. એ કસ્ટોડિયલ ઇન્ટ્રોગેશન જરૂરી છે.
નામદાર હાઈકોર્ટ નો ઇન્ટ્રીમ ઓર્ડર હતો એ દરમિયાન તપાસ અધિકારી સમક્ષ આવ્યા છે.
મને તમારો અવાજ નથી આવતો માઈ.
વચગાળાની જે નામદાર હાઈકોર્ટે હુકમ કરેલો આરોપીને તપાસમાં જવા માટેનો તે દરમિયાન આવ્યા છે. ત્યાર પછી તપાસ અધિકારીએ
You first, according to you, arrest is necessary. For the reason,
અને નામદાર સુપ્રીમ કોર્ટે એમની ઉપર રિલાય કર્યું ત્યાર પછી એમને નોટિસો આપેલી છે.
નહીં પહેલા તમે હાઈકોર્ટના ઓર્ડર પછી તમે શું કહેતા? હાઈકોર્ટે ઇન્ટરિમ રિલીફ આપી
એ દરમિયાન આવ્યા છે તપાસમાં ને એ દરમિયાન જે મોબાઈલ નંબર જણાવ્યો છે 9321637556 કે જેની ઉપરથી ફરિયાદીની કંપનીમાં પરચેઝ મેનેજર તરીકે નંદુ નામની વ્યક્તિ હોવાનું જણાવીને ઓર્ડર જે આપવામાં આવતા હતા એ નંદુ નામની વ્યક્તિ જ હાલના અરજદાર આરોપી છે.
વેઇટ એવું તમને સીડીઆર પરથી તમને લાગ્યું?
નિયમના નામે જ છે એ નંબર. અને એ સીડીઆર કઢાવ્યા અને એ સીડીઆર માં એમનો જ નંબર અને
યસ,
એ નંબરમાં એની માતાનું નામ સેવ કરેલું હતું અમ્માજાન તરીકે. પરંતુ એ એક જ ઇન્સ્ટ્રુમેન્ટમાં આ કાર્ડ વાપરવામાં આવતા હતા અને એ બંનેના સીડીઆર અને લોકેશન એક જ જગ્યાના દરેક વખતે મળે છે. એટલે નંદુ નામ ધારણ કરી હાલના અરજદાર આરોપી મોહમ્મદ મુર્શિદ કંપનીમાંથી માલ મંગાવતા હતા અને એમના નામની ટ્રેડિંગ કંપની HSN જે કંપની છે એમાં યોગીરાજમાંથી માલ ગયો છે. જીએસટી નંબર
એમની જ કંપની?
હા, HSN ટ્રેડિંગ કંપની. હા,
સો અહીંથી માલ ખરીદીને HSN કંપનીમાં ગયો?
એ સાહેબ યોગીરાજ મારફતે મંગાવે, યોગીરાજ નામથી ફરિયાદી પાસે મંગાવે. યોગીરાજમાંથી હાલના અરજદારની જે ટ્રેડિંગ કંપની છે એમાં માલ ગયો છે.
વેઇટ, મંગાવે યોગીરાજ નામથી?
હાજી. અને મંગાવનાર પાસે
પોતે પરચેસ મેનેજર છે ઓફ યોગીરાજ ટ્રાન્સપોર્ટ એવું કહીને મંગાવતા. ઓકે, have some patience. Let go. Wait. તમારા કહેવા મુજબ યોગીરાજના નામે મંગાવતા પણ જતો એમની કંપનીમાં,
એટલે યોગીરાજના મેનેજર તરીકે
ઓળખ આપતા. પરચેસ યોગીરાજ કરતું?
હા, યોગીરાજ કરે અને યોગીરાજમાંથી માલ એમની ટ્રેડિંગ કંપનીમાં ગયો. જેમાં મુદસર અને આસિફ બે ભાગીદારો છે.
વેઇટ. So present petitioner and Asif was partner in that.
હાજી.
Okay.
અને ત્રણ કંપનીઓ છે. HN કંપની છે એમાં એમની માતા અને મુદસર.
So ફરિયાદી એમ જ માને છે કે યોગીરાજને વેચે છે.
હા,
યોગીરાજને કોલ સપ્લાય કરે.
યોગીરાજ વાળા સંજય છે એ પણ આરોપી છે.
એ કઈ રીતે?
એ એમની પેઢી છે. અને એમનું જે ગોડાઉન ભાડે રાખવા જાય એ હાલના અરજદાર આરોપીએ જ રાખેલું છે. એ માલિકનું પણ નિવેદન લીધું છે.
યસ.
અને ત્યાર પછી ગોડાઉનો પણ બંધ કરી દીધા છે. ફરિયાદી ત્યાં સ્થળ ઉપર જઈને તપાસ કરી તો ત્યાં ગોડાઉન બંધ હોવાનું મળેલું છે.
યસ.
અને કુલે 9 કરોડ જેટલી રકમનો માલ આ વિદેશી કોલસો મંગાવેલો છે. એમાં એમની જે કંપની છે HNN ટ્રેડિંગમાં 3,74,51,000 HN ટ્રેડિંગમાં 41,75,000 અને લિમ્બ્રા ફ્યુલ કોર્પોરેશનમાં 20 લાખનો એમની
યસ.
અને સુપર એન્ટરપ્રાઇઝ જે એમના ભાઈ આસિફની છે ઈશાકની છે એમાં 15 લાખનો માલ ગયેલો છે. આ બેંક સ્ટેટમેન્ટ મુજબના આંકડા છે.
બાકીનો આ તમે કહ્યું 3 કરોડ 51,000 51 લાખ 20 લાખ 15 લાખ 5 કરોડ બાકીનો
આ પોતાની કંપનીમાં ગયો, બીજી અલગ અલગ કંપનીમાં.
એટલે આનો સરવાળો તમે કરો તો એટ ધી મોસ્ટ 5 કરોડ. તમારું કહેવા મુજબ 9 કરોડ નો રકમનો વિદેશી કોલ્સ છે. બાકી
ટોટલ 9 કરોડ.
એ ક્યાં ગઈ બાકીની?
બીજી કઈ કંપનીમાં ગઈ? ટોટલ ટ્રાન્ઝેક્શન આપ્યા છે. એફિડેવિટ નું આ કોલમ આપ્યું છે. એમાં HN માં 12,49,71,000 નો ટ્રાન્ઝેક્શન છે. HN માં 1,48,64,997. લીબ્રામાં 61,57,000. એટલે આ ટોટલ ટ્રાન્ઝેક્શન બેંક સ્ટેટમેન્ટ મુજબના આમાં છે.
ઓકે, ઓલરાઈટ.
અને એમને નિશાની એનેક્સર L થી જે સેટલમેન્ટ બાબતની પ્રપોઝલ મોકલેલી છે એમાં પણ એડમિટ કર્યું છે અને સેટલમેન્ટ કરી લેવા માટે ફરિયાદ પક્ષને જણાવ્યું છે. એમાં પણ 3,33,71,952 સંબંધે આંકડાનો ઉલ્લેખ કરેલો છે. અને એમાં ટર્મ્સ કન્ડિશનો પણ લખી છે. મેટર કોર્સિંગ કરવા માટેનું પણ પ્રપોઝલ મોકલેલી છે. એ 31/5/23 ના રોજ. તેમજ હાલના અરજદાર આરોપીએ નામદાર કોર્ટમાં આગોતરા જામીન અરજી કરેલી, જે નામદાર સેશન્સ કોર્ટ દ્વારા રદ કરવામાં આવેલી છે. જે જામીન અરજી 36/22 છે. ને નામદાર હાઈકોર્ટે પણ રદ કરેલી.
યસ.
પછી છેલ્લે નામદાર હાઈકોર્ટે જે ઇન્ટ્રીમ ઓર્ડર કરેલો, ત્યાર પછી 22/8/22 નો જે ઓર્ડર છે એમાં 13/6.2 માં એપ્લિકાન્ટે મિસલીડ કરી સપ્રેસિંગ કર્યાનું ઓર્ડરમાં ઉલ્લેખ કરેલું છે.
પેરા નંબર
6.2. અને એમનો સ્ટે વેકન્ટ કર્યો છે. ઓર્ડર જે કરેલો એ વેકન્ટ કર્યો છે, ડિસ્ચાર્જ કર્યો ઇન્ટ્રીમ. એટલે તપાસમાં એમની જરૂરિયાત હોય અને એમના વિરુદ્ધમાં એક મલાડ પોલીસ સ્ટેશનમાં મુંબઈ ખાતે પણ ગુનો દાખલ થયો.
All right.
તે ઓર્ડરની કોપી આમાં પેપરમાં સાથે રાખી દીધી.
May I just quickly rebut in 2 minutes? I'll not take more than 2 minutes.
Yes.
Not whatever I could understand from my learned friends' submissions is that the HN trading is on my mother's name, which is right, which even I made my submissions. I am partner with Asif Sheikh in SHN, and that is why I was explaining the matrix and the 4 pillars of the conspiracy, which falls flat on the very substratum of the issue that you have you have gone ahead and improvised your statement. So essentially, you first made a false statement before the investigating officer that all coal was transferred by Asif. Third, my lords, if my learned, I am not aware, but what was argued before Gujarat High Court is that they had gone to the godown and the godown owner has said that yes, Sanjay Bhai's transporter Asif Sheikh, I know, but I just overheard, and subject to correction by my learned friend, I just overheard that the agreement of godown was with me. But that's not the case. There cannot be any agreement of the godown with me. And third, my lords, today, lords, Asif Sheikh, who's my partner in SHN, he is out on anticipatory bail. Deepak Dholu, against whom the entire allegations are that about misrepresentation, he is out on anticipatory bail. The principle of parity demands this, that I should be granted protection. And so far as my learned,
Their roles are very limited, Asif and Deepak Dholu.
sorry, my lords,
Their role are limited. You have purchased the call.
as such, my lord, Asif is also my partner in SHN.
Okay.
Yes. No, grounds are limited, but ultimately, lordship, for an offense under 420, misrepresentation has to be there. My allegation of qua misrepresentation qua me is that I acted as a purchase manager of Phoenix Infra. Phoenix Infra allegedly purchased 70.
Yogi Raj.
No, allegation is for Phoenix Infra, not for lordship. I'll point out from the FIR. And in fact, that is itself my case, my lord, which I forgot to argue in the earlier part, that I, even as per prosecution, my entry happened at the fag end of your transaction with Yogi Raj. So
All right.
for an offense to be under 420, lordship, the intention to cheat has to be right from the inception. And lordship, so far as these transactions are concerned, my lordship, taking figures from my learned friend, may I point out paragraph 29 of my application. I have produced a summarized table about the transactions between my 3 firms and Yogi Raj and Phoenix. And your case is for 8 crores. Lordship, I have done business worth 24 crores with them. And I have paid the money. So if I had no intention to pay, or if I had intention to cheat, I would not have been paying monies to you.
All right.
I'm highly obliged for the patient hearing.
Any of you have produced the copy of that High Court judgment?
Lordship, I'll in 5
તમે
minutes
રજૂ
I'll
કરું
just
છું?
carry the printouts and
કરું છે રજૂ.
આપી
You
દીધી.
provide me the copy.
I-
All right. 10 દિવસ પછી પોસ્ટ કરો.
my only request, my lords, that the High Court order as such has been then the scope has been limited by the Honorable Supreme Court, that it should not as such influence my lord's independent decision.
The order is in which the Honorable Apex Court thought not fit to interfere. So I just want to know that what
Yes,
was
of course. My lords are absolutely right if my lord wants to. But may I only point out that my intention was not to suppress it. I have given a narration in my pleadings also that the order was passed. So tomorrow it should not happen. Lordship, ultimately clients will come and go, but I am my lord's officer. So I don't want to
When,
walk out of the court
when
with
you
the
were
conscience.
on chronology,
Ah.
at a moment, I just pose a query why it is not
Yes,
produced.
but ultimately, lordship, I am your officer. I don't want to walk, when I leave the court, I don't want to leave that I have made any attempt to, suppress a document or something. I don't want to do that, because then that's a blot on my profession, which I would not
Ah.
want to
All.
work. I'm deeply obliged.
Justice. Anybody is attending the matter on your behalf from this bar?
Mr. Ahir.
Okay. કઈ તારીખ આપી છે? 17 17.
17.
77.
Would my lords consider to protect me? I'll go and attend the police station in the meantime. Whatever documents additional.
At present, no order.
I'm obliged.